Entries of appearance, please.
Brave Taylor on behalf of the people.
Morning, Mr. Jordy.
Morning, sir, Your Honor. I'd first like to say that I am here. I am Darren Allen Jordy, the living man. And I would also like everything on and for the record, sir. And I would like transcripts of that. I would like to reserve all my rights. I am here by special appearance and summons and duress of warrant. And I am here to also challenge the jurisdiction of the court respectfully.
Okay.
I have filed a motion with the clerk already this morning. You have copy for the district attorney.
Have the people received a copy of that motion?
We have, Your Honor. I do believe one was filed into the case file, but we have just accepted an additional copy.
All right, just a moment, please. Just going to take a moment to review that motion as it was just filed earlier this morning.
Absolutely, sir. Understand. I would also like to say on and for the record that the civil matter already being handled in Denver County. I've provided a case number for that as well.
All right, a handful of initial issues. The court has had an opportunity to review the pleading that was filed by Mr. Jordy earlier this morning. That's a motion to dismiss challenge for or of jurisdiction. And a couple of the issues you brought up initially, Mr. Jordy, first with respect to the record of these proceedings, everything that is said in this courtroom is being recorded. And that's being recorded on this FTR machine over here.
Thank you.
If you would like transcripts of this proceeding or any other proceeding in relation to this case,
Yes.
you are welcome to request those transcripts, and you can obtain a copy of the transcript of this proceeding and any future proceedings through the request.
From the clerk's office.
Correct. Yep.
Understand.
So with respect to the record and the transcripts issues that you raised, those can be requested, as I mentioned a moment ago. You are on a summons in this case, and the summons required an appearance this morning. The summons will be continued through the duration of the case, and so ultimately, you'll remain on that summons as long as you continue to appear for any future court settings. If you fail to appear, then the summons could be revoked and the court could issue a bench warrant for your arrest. But for today, you are in fact on that summons. With respect to the nature of this proceeding, this is not a civil case. This is a criminal case. I see that Denver case 25 CV 33908 appears to involve you as a defendant in a civil matter in Denver. Looks like Long Building Tech Inc. versus Jordy
Correct.
Mechanical Inc.
Correct.
And so to the extent that that civil case relates to the same allegations that underlie the criminal case, that would be a collateral matter in civil court, whereas this is a criminal case.
I completely understand that. I would also like to point out to the court that these checks that are in question here in the criminal case, they were transferred on the property of 5900 East 39th.
Before you go any
Avenue,
further,
Denver.
I'll just caution you against discussing the facts of your case. Like I said a moment ago, everything you say in this courtroom is being recorded. There's a district attorney present, and they can order the transcripts as well, and they can use those transcripts against you. So I'll just caution you against discussing the facts of your case.
Thank you, sir. Thank you, sir.
So with respect to jurisdiction, ultimately, the allegations in this case, the complaint and information that was filed previously was filed back on April 21st. Alleges fraud by check, which is a class 3 felony, and we'll talk about the offense in a moment. Are the people alleging that the fraud or some part of this this culpable act occurred in the state of Colorado and county of Arapahoe?
We are, Your Honor.
Okay. And so the people are alleging, Mr. Jordy, that the offense occurred at least in part within the state or state of Colorado and county of Arapahoe. And so that is the basis for this court's jurisdiction. This is a criminal court in Arapahoe County, and the people have filed a single count alleging that a crime occurred in part in Arapahoe County. And so with respect to jurisdiction, that is a basis under the law to potentially transfer a case to the court that does have jurisdiction. It's not a basis, however, to dismiss a criminal case. And so with respect to your motion this morning to dismiss for lack of jurisdiction, I don't see anything in terms of the law or argument in that motion that would suggest that this court lacks jurisdiction under the circumstances. If you would like to file a pleading noting the basis upon which you believe the court is deprived of jurisdiction and that it should lie elsewhere, then you can file a motion to transfer the case, but that would be the relief that's available under the law under those circumstances.
The Constitution of the United States under Article 3, Section 2 states that any time that the state is a party against a citizen of that state, the Supreme Court has original jurisdiction.
The United States Supreme Court?
It says the Supreme Court has original jurisdiction.
Okay. Well, the 10th Amendment of the United States Constitution notes that all rights not specifically reserved to the federal government are essentially within the purview of the states. And that's what's essentially occurred here. The state of Colorado has passed the statute that has criminalized the offense in question, fraud by check. And so that's the basis of this court's jurisdiction, and obviously the people of the state of Colorado filing accounts accordingly. And so the court is finding jurisdiction this morning. I don't see any of the argument or law in your motion that would suggest otherwise. And so that will be the court's finding this morning. If you have additional argument or law you want to cite, you're welcome to do so. And so with respect to the initial documents that we need to address, Mr. Taylor, did you have a mandatory protection order, Rule 5 advisement?
The defendant was unwilling to sign them when I provided them to him. He said he wanted to be advised by the court first.
All right. And so, Mr. Taylor, I'll ask you to approach with those documents and I'll talk through those with Mr. Jordy.
Sure, absolutely. Yes.
Thank you. All right, so Mr. Jordy, I'm going to advise you as to your rights pursuant to Rule 5. If you've got any questions about this advisement, you're welcome to ask those as soon as I'm finished. Please pay close attention because there's quite a bit to get through here. So, sir, first and foremost, you have the right to remain silent. You do not need to say anything to anyone about the facts of your case. Any statement that you do make can and may be used against you unless it is something that you say to your own lawyer or something you say to the district attorney while attempting to negotiate a plea agreement. You have a right to be represented by an attorney, and if you cannot afford an attorney and you are considered indigent based on state guidelines, you may request that an attorney be appointed to represent you. If the public defender is appointed to represent you while you are in custody, which is obviously not the case here, and then you are released from custody, you must then travel to the public defender's office and reapply if you wish to continue to have such representation. Because you were never in custody in the first place in this case, you would need to apply out of custody if you wish to have a public defender. The district attorney represents the state of Colorado and does not represent you. The district attorney cannot give you legal advice. In most cases, you have the right to have a reasonable bail set. We may discuss bail today when your case is called. And if you are a defendant on a Victims' Bill of Rights case, otherwise known as the Victims' Rights Act, and bond has already been set by schedule or on a warrant, the bail cannot be discussed until the court can find compliance with the Victims' Rights Act. If this applies to you, your case would be set over expeditiously on the issue of bond to allow for compliance. And so again, sir, you are on a summons in this case. We won't be addressing the issue of bond this morning. And I'll just note for the record that this case does not involve a Victims' Rights Act offense. You have the right to a speedy and public jury trial, or if the district attorney agrees, a trial to the court. You are presumed innocent, and if you plead not guilty, you have the right to require the district attorney to prove your guilt beyond a reasonable doubt. At trial, you have the right to cross-examine witnesses, to testify on your own behalf, and the right to subpoena witnesses to testify on your behalf. You also have the right to appeal any rulings or decisions in the event of a conviction. And if you are charged with a petty offense, which is not the case here, you are entitled to a jury if, within 21 days after the entry of a plea of not guilty, you make a request to the court for a jury trial in writing and tender to the court a jury fee of $25 unless the fee is waived by the court because you are indigent. If you are alleged to have violated any law pursuant to Title 18 of the Colorado Revised Statutes, which is the case here, the law requires that a mandatory protection order will enter against you, and I'll talk to you about the terms of that order in just a moment. The protection order will state that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are charged with committing, and other conditions may be ordered by the court as part of the protection order as well. Compliance with the protection order will be mandatory and could be the basis of contempt proceedings or new charges filed against you, which may be a misdemeanor or a felony. You may be able to resolve your case by plea agreement, but please keep in mind that any plea of guilty which you may enter must be a voluntary plea and not the results of any threats, coercion, or undue influence on the part of anyone. Any agreements you make with the district attorney must be in writing. After you have read your rights, you may have a conference with the district attorney to determine if you and the district attorney can reach an agreement regarding your case. This could also be an opportunity for you to obtain more information about your case, but you do not need to speak with the district attorney if you choose not to. After you have read this advisement, whether you choose to speak with the district attorney or not, your case will be called up by the court, as it has been, to either accept an agreement or set the matter for future court proceedings, such as motions, trial, appearance of counsel, or some other setting. And so based on that advisement, do you have any questions for me about any of those things we discussed?
The only thing I would have a question on right now is I have the right to indictment, correct?
The right to indictment?
Yes, not by trial by information.
No. So the people are permitted to proceed by complaint and information. That's how they proceeded in this case. And so there's no grand jury indictment. That's one of the ways that people can seek criminal charges. But they can also file criminal charges based on a statement of probable cause and a finding of probable cause by a judge, which is what ultimately this is a summons case. And so no court has found probable cause and you're not in custody this morning. But the people are proceeding by complaint and information based on the fact that this is a summons case. So there's no right to a grand jury indictment.
I'm sorry, and I mean no disrespect, but I do not understand that, but I will, I don't know what to say after that.
Well, I can't give you legal advice here. Obviously, if you'd like to seek legal advice, you're welcome to retain counsel, and we'll talk about that in just a moment. But in this case, the people have simply filed a complaint and information, as I mentioned a moment ago, that charges that one offense. I'll talk to you about the nature of that offense in just a moment.
Sure.
But in terms of the Rule 5 advisement that I just read, the rights that you have, do you have any additional questions about any of that?
No, sir.
All right. And sir, have you ever served in the U.S. Armed Forces, or are you a veteran?
No, sir.
All right. I'm going to mark the form no, and I'm going to stamp this as reviewed with and acknowledged by Mr. Jordy on the record today.
Thank you, sir.
Of course. Mr. Jordy, the next document we need to talk about is this mandatory protection order. I alluded to this a moment ago, and this order will enter in your case this morning. The order will name you as the restrained person. It will name Michelle Van Shiver as the protected person. The order does not involve a crime of domestic violence or a Victims' Rights Act offense, and it will contain a handful of terms. First, that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are accused of committing. Second, you will vacate the home of the victims and witnesses and stay away from any location they are likely to be found. And third, you will not contact or have direct or indirect communication with the victims or witnesses. Finally, you will be restrained from the location of 5001 South Zuni Street in Littleton, Colorado. And those will be the terms of the protection order. Do you understand each of those terms?
Yes, sir. And with the exception that I don't even know who that is.
Okay. Well, if you happen to run into this person understanding that fact, then you should just turn around and walk away. Don't communicate with the person and stay away from anywhere they're likely to be found.
Can you tell me who it is?
What's that?
Can you tell me who it is?
The protected person?
Yes.
Michelle Van Shiver.
No idea.
Okay. Well, like I said, if you happen to run into that person, just turn around and walk the other way if you don't know who she is. But the terms will nevertheless apply to you, so please make sure you comply with them. Any other questions about that?
No, sir. No, sir.
All right. I'm going to stamp this as reviewed with and acknowledged by Mr. Jordy on the record today. Mr. Jordy, the next order of business is the one-count complaint and information that was filed in your case. We also discussed this a moment ago. The single count charged against you is a Class 3 felony, and the allegation is fraud by check with a value of between $100,000 and $1 million. So that penalty, the maximum penalty for that particular offense is 4 to 12 years in the Department of Corrections. It also carries a maximum fine of $750,000 and 5 years of mandatory parole. That count alleges that between and including September 19th and November 15th of last year, 2025, you, Mr. Jordy, knowing that you had insufficient funds with the drawee, U.S. Bank, with intent to defraud, unlawfully issued 2 or more checks within a 60-day period totaling $100,000 or more, but less than $1 million in the aggregate to Long Building Technologies for the payment of an HVAC unit. So that is the single count that's been charged against you. Do you understand the general nature of what you're accused of in that count?
Yes, sir.
Do you have any questions?
No, sir.
All right. So this count is a class 3 felony. It will be eligible for a preliminary hearing in this division, even though you're out of custody. So your case is going to remain here in this division for now. Do you have a plan for an attorney? Do you intend to apply for a public defender or hire private counsel?
Sure. Hire counsel at this point.
Okay. And do you have anyone in mind at this stage?
No.
Okay. So what we'll do is we will set you for an appearance of counsel about a month down the road. We'll give you some time to retain counsel. Please make sure you stay on top of that issue between now and the next court date. And when you come back about a month from now, we will check back in on the status of that, and hopefully you'll appear alongside your attorney on that next court date as well. Any additional questions from me at this stage?
I don't think so, sir.
All right. Anything from the people on this case?
No, Your Honor. Thank you.
All right. A good date for appearance of counsel in Division 302, please.
We'll set July 23rd, 8:30 a.m., Division 302.
All right. Mr. Jordy, would you like a setting slip with that next court date on it?
Yes, please, sir.
That's coming out to you now. Do we have a fingerprint order in this case as well?
Thank you.
Do you need copies?
Is there anything just sign? Okay. Thank you, ma'am.
All right, sir. Your summons will be continued through that next hearing date. Good luck with that attorney search.
Thank you, sir.
Have a good day.
Appreciate your time.